Okay. But Your Honor, I would also say, and I would do as the court has instructed, period. That's a full stop.
I love when attorneys say, I'll follow your orders, as if you have a choice. I mean, I guess you have a choice. I can hold you in contempt. But
Judge Whitaker does not want to be there.
But have raised in defense that the police targeted Mr. Williams. I stand by that. It came out in evidence. Just for instance, when this honorable court was here, it came out in other factions of the case before. Mr. Copeland's statement, which was admitted over objection on June 10, 2015, he's with police officers. And they specifically say, we don't want Shannon. He's a little fish. We want a big fish. And it comes out, I want Thug. I want to know where his money's from. This was embedded in the case by the prosecution, and Mr. Copeland testified, I knew who they wanted.
These are all facts. They didn't say they wanted a big fish in an interview. They literally did.
And if the district attorney who's testifying, and he's an honorable man, he's allowed to say what his conduct was, why he did this, why he didn't do certain things. They asked yesterday, or the court may have said, yeah, but you attacked why some people were indicted and some people weren't indicted. I believe that came from the honorable court. I believe that's a waiver of work product. I mean, we're getting very close to strategy, and they're revealing, they being the DA's office through this witness, may be revealing to an adversary, which waives attorney work product, what they did and why they did it. And if that's true, I just know myself, I want to follow the law. I'm going to serve a subpoena. It'll be met with a quash, I'm sure. And you're going to have to go through all of the in-camera inspection of all emails, text messages, memos from meetings. I'm going to put Paul Howard on my witness list because this case has been languishing before indictment for approximately 7 years. And I don't see why we're doing it, because it could extend the trial, which is fine. But it really is going to be met by a blizzard of people reading all, if you allow it, of the state's inner workings. So then we can confront Mr. Sprinkle. Well, you made this decision.
So since they're opening that door, he's saying they're getting close to waiving attorney work product, which opens the door to pretty much they can ask him about why they made these decisions.
But if his strategies are coming in, he will be asked. Now, I'm confident, knowing the Honorable District Attorney elected Willis, she has control of this case.
So suddenly the judge dismissed the jury, and now something's happened with Quindary Zachary.
Contrary to insinuations that have been made today, I have no idea what's about to happen. However, Mr. Zachary is not going to answer any questions, which strikes me as a possibility. I think we should determine what Mr. Zachary's going to do in his condition and everything else before the jury comes out. His condition, his pleasure, I don't...
No, I know what you mean by his condition. What do you mean by, I think we should determine what he's going to do in his condition?
Well, I don't know what he's going to do, but if he's going to refuse to answer questions, I don't believe that would be appropriate for that refusal to occur in front of the jury. And I don't know if he's going to do that or not. Let me be clear.
So something else everybody's going to have to deal with.
This is fucking ridiculous. They're putting a fucking state witness that could potentially just be too high to even answer something.
Having to deal with someone on narcotics that's going to claim to not remember anything is quite honestly ridiculous. If he's going to testify, he needs to testify. If he's not and just going to say, I don't recall anything, then we're not going to be able to cross-examine him. If he's going to say, I'm too high to answer questions, that's not effective opportunity to confront a witness. And so I don't know what's going on here. I don't know what any of this is. But if we're going to call a witness to stand, he needs to be able to answer questions. If he can't, then I'm not able to cross-examine.
This is all just nonsense. Literally everything.
The possibility of you needing to have a doctor come give us some information about impact anything in his system might have. Has it? I'm asking about the understanding that you have of Mr. Zachary's consent to let the state communicate with his doctor about his condition.
The other day. I don't know. He needs to come out and just put it on the record. Hey, I consent. We need to find out who the doctor is. I don't know who's on there.
That was my point, is I have no idea who's on the phone. How about a Zoom call?
That's what we're trying to establish, Your Honor. We have his email address.
What are they violating? What is it called? HIPAA?
He gave oral consent a few days ago to a doctor that he knew.
Oh my God, this is actually a circus. Like, there's no other way to describe it.
What